I'm the District Attorney of the Alcovey Judicial Circuit, and along with Senior ADA Alex Stone that is here, we represent the state of Georgia in this case. And I'll get right to it because I think that the court and opposing counsel obviously get right to the point of foreseeability. And I think that one of the sort of disagreements between the appellant and appellee in this case is what is it has to be foreseen? I guess that's not the right word, but the actual act that happened or that something could go wrong. And I'll say, actually, I say that something may go wrong as a quote from this court's case just 2 months ago. It was Wilson v. State, February 7th of this year decision, I think docket numbers S22A0885. And in that case, what I kind of call was the universe of foreseeability. It talks about essentially any marijuana transaction, it is foreseeable that someone could die. Something may go wrong. It doesn't say that something specific, that someone may pull the trigger and kill somebody. It doesn't say that somebody could rob someone. It says something may go wrong. And so I think this court has made that sort of universe of foreseeability very large.
Is that a generalized standard, or is that particular to that specific circumstance?
Well, I guess it's generalized to the nature of...
Because if you think about daily life, like something could go wrong all the time.
Well, right. I don't mean to take it that far. What I'm saying is that...
Yeah, I'm asking you whether that principle can be imported into every context.
I mean, those cases basically say drug transactions, given the nature of what they are and what we know. I mean, half of our murder cases are drug transactions gone wrong.
Correct. As what I'd say, though, is it goes back to as far as, I think, Justice Peterson, you sort of asked, or Beth, one of you asked the question as far as, how likely does it have to be? Well, there's also, it's with Wilson, marijuana transactions. How many marijuana transactions are there a day in the state of Georgia? I'd say there's a few, or a lot more than that. And a lot of them do not end in anything bad whatsoever. But if it does end in something bad, then the people involved are responsible. If it leads to a death, they're responsible for that death. And I think if you're going to sort of an analogy...
That precedent has been pretty strongly criticized as, a very minor marijuana transaction serving as a predicate for felony murder. And
I've read some of that criticism. I agree, but this court also still said that 2.5 months ago.
Sure.
And I think if the world is that it is foreseeable that someone could die in a marijuana transaction, then it's also the world that if you were raising a 2-week-old in a house full of violence and meth, that something may go wrong. And I think that's why I'm tying those two cases together, because...
So how specific does that thing that may go wrong need to be? I mean, here where the indictment ties it specifically to the death of the child.
Correct.
Does it need to be, not necessarily that this particular act was foreseeable, but that the death of the child could have been the thing that goes wrong?
Well, I guess that's sort of, does that then tie into, is that more of a jury issue? Because it could be foreseeable. And I think
is it always foreseeable? Is every mother who has an abusive boyfriend and a child with that boyfriend on notice that that boyfriend could kill her child if he's using cocaine or abusing opioids? Or is it just methamphetamine? Or is it...
I think it's a totality of everything. It's a totality of everything. I mean, I think the point is marijuana, obviously, I think no one's making that argument there.
But we do have to, we do have to figure out where the line is, because this felony it doesn't here, but it could serve as a predicate for felony murder, right?
Well, I think the state's argument was that it did, but that's a separate issue, yes.
So, and if we say that this evidence is in fact sufficient to prove this particular felony, then it also would be sufficient to convict someone of murder and sentence them to life without parole, right?
Where as far as this contributing to delinquency that caused death,
yes,
would also be an underlying felony.
It could be a felony predicate for felony murder.
Could be,
Okay.
yes.
And then, sorry.
Go ahead.
Go ahead.
I mean, one would then naturally have to ask how many cases of felony murder would be indicted on that basis, including situations where, people are in abusive relationships and cannot leave,
right,
or reasonably think they cannot leave. Is the state going to indict felony neglect and felony murder in those situations too?
I don't know. I mean, I think in this situation you have the totality of everything as far as them using meth. It's a violent household. There is other individuals who are wanting to watch this child.
What's the state's, is there a disagreement between you and your brother across the way about how often the violence happened? Because the way you're presenting it is different than the way he presented it.
Well, I think he said there's no violence towards the child, which I agree. I don't think there was a history of violence to the specific child. Now, again, I mean, it's been 2 weeks. But obviously, I think there was evidence of violence between Mr. McNabb and Mrs. Bell, including bruises that she had on her body while she was being interviewed by law enforcement.
And so how does that inform the question of reasonable foreseeability?
Well, I guess that's I don't think there is I don't know how the court would draw some sort of bright line of how
That's our job-
likely it would
that's
have
our
to be.
job. Yeah, we have to draw those lines, not just in one case, but what we say in one case applies
Right.
to others.
Right.
And particularly when the consequence of that line is if you're on one side of the line, you're potentially guilty of murder, like that's a big deal line.
But go back to sort of what I started with, though, that I think that the court has that universe of foreseeability. The court has, it's a big universe. I mean, there's cases of, somebody, Calhoun v. State is a case just a couple years ago out of this court, 308 Georgia 146, where someone's driving, or fleeing from police at a high rate of speed. GSP goes and pits that person, and the passenger of the fleeing individual dies, which is somebody else doing the act, sort of like here.
These cases that you're referring to seem different in kind.
Well, and I guess how I compare them
When multiple adults are engaged in high-risk behavior with fairly well-known consequences, that seems like a different situation.
I think why they're comparable, though, is that the defendant in each of those created the circumstances that led to the death. Just like here is and I understand that's the disagreement, is that she didn't create the circumstances, McNabb did.
Circumstances that led to the death in Calhoun was a high-speed chase. People die in motor vehicle wrecks all the time based on speed. What circumstances were created there, I mean, here, that are similar to that?
Well, no, I guess what I'm saying is that's more to that some other outside law enforcement got involved and actually caused the actual collision which led to the death. And it's just that that another car did that. And I guess that goes to the idea that McNabb is obviously the one that did the actual injuries
That's not
in
a
this
proximate
case.
cause argument, that's an intervening act argument, right?
Well, no, I think the issue, though, is it a sufficient intervening act? Is it a unforeseen intervening act?
I think it is generally understood to be fairly foreseeable that if you were engaged in a high-speed chase from police are going to do something to try to get you to stop. And that thing, given that you're going at a high rate of speed, may be very dangerous to lots of people involved.
Right, but I also think that if, just as Bethel brought up to opposing counsel, was that are you going to have somebody that you know abuses methamphetamine babysit your child? You're not going to, because you're concerned that something very bad may happen.
Well, but I think that what you just said is a fairly common sense argument, but whether you make a choice that is a good choice or not is a different question than whether that is a criminalized choice.
Right, no,
Potentially criminalized choice.
Yes.
Let me ask it this way. Under the facts of this case, let me change one factor. A defendant is in a relationship with an abusive father. The parents both allow other people to come in and out of that home and use drugs, and that they themselves and the other people that come in and out of their home that use drugs are abusing Xanax. Same outcome? Is the mother on notice that the deprivation of that child, by putting that child, which they concede, in that environment, it's reasonably likely that the father will murder that child?
Just changing just Xanax from meth is essentially what you're asking. Okay. I would say I think that is some evidence that it is foreseeable.
So any drug use at all?
Well,
What about alcohol? Which is legal,
Right.
but can also lead to things.
and I think if you have a history of the two people parenting the child who have a history of alcohol instead of methamphetamine, and that some of that history also includes some violence, even if it's just between them and not the baby, then yes, I do think there is some foreseeability that, again, something may go
And so
wrong.
now that mom is not just guilty necessarily of felony deprivation, but potentially felony murder.
Because every
I
one
still
of
go back
those,
to that. I think with the
Counsel,
felony- I'm sorry, go ahead.
every one of those drug uses, that's the only thing I've changed in the hypothetical,
Right.
would constitute a felony, correct? And that felony could be the felony predicate for felony murder.
As far as the possession of the actual drugs
The
itself?
deprivation.
Of the deprivation?
Felony deprivation.
Right, and I guess with that, though, is the deprivation that led to a death, I guess it's not some rule entity issue that
The
with that being
deprivation
felony
that
murder
led
too,
to the
though?
death was inviting that child into, or inviting that abusive father into that environment. The same thing here is placing that child, the child is deprived. The child's deprived because the mother, they concede, allowed the child to be around an abusive father in a drug-using home, using methamphetamine where other people were in and out of the home.
Right.
That's the deprivation, right?
Yes.
Okay.
And I guess to add to...
So is there any drug to which that would not apply, your theory?
I think if there's evidence of the nature of this relationship that these two individuals had, and let's be honest, I mean, that was in large part because of their drug use, then I think, yes, I think it's foreseeable then. And I would add...
But in response to my question about alcohol, you also said it doesn't have to be illegal drugs, it could also be legal things.
Right, which alcohol, yes.
Yeah.
And I guess I'd add to that is sort of taking a hypothetical a different way, is I still think Ms. Bell would be, it would be foreseeable if someone other than, if the other person that was coming in the house using meth had also caused harm to the child in this situation, instead of Mr. McNabb, I think there would also be an issue there.
Is it your argument, just to be clear, I mean, because we get in the line drawing, is it your argument that it would be foreseeable, or that that would be a jury question?
That would be a jury question.
Yeah.
And I think because this court has 4 times, I looked at the exact quote, and I think the last time was 2018, Stribling v. State, 304 Georgia 250, this court said, what constitutes proximate cause is undeniably a jury question. And I think
I mean, it's a sufficiency question, right? Is the evidence sufficient for the jury?
is there some evidence
Right.
that a jury could say that this was foreseeable?
So what about, let's say that the father didn't commit this crime, that instead some of the people they invited into the home knew there were drugs in the home, broke into the home to steal the drugs, and during the burglary, killed the child.
Yes, and that's I started to kind of say that as well. That, yes, I think that would be foreseeable as well. Especially in this case with alcohol may be different in that situation because it's not illegal, but you're having a illegal substance in your house. And again, we're sort of simplifying the...
So if someone came into your home and killed your baby, you would be tried for felony murder?
Could be.
If you're in this relationship where drugs are a huge part, and I think we're sort of limiting the facts, we're trying to make it, like, methamphetamine was a huge part of their entire relationship.
Counsel, you keep saying that you think it's reasonably foreseeable. Do you have a case anywhere where any court has found that the death of a child or someone in the home is reasonably foreseeable to a parent who has contributed to the deprivation of that child? I mean, any case, because we talk about foreseeability because on all these other cases, because it happens all the time, we see it all the time in these other cases. Is there a case anywhere in this country where any court has found that this is a jury issue under the facts of this case?
I've not found one. What I'd say is the closest I found here, at least in the state of Georgia, is Williams v. State, is 290 Georgia 208. It's a 2015 case. Is that possessing cocaine in the house with kids, that it's reasonable foreseeable that the child may ingest cocaine. Johnson v. State is 292 Georgia 856, is a 2013 case. In that case, the parent failed to prevent a 3-year-old from accessing legal medication, and the child died from that. I obviously understand those are different because the medication is what killed the child, not somebody else. And then also, I think a case the Court of Appeals cited was the BLM case, juvenile court, the reckless abandonment that led to death, where essentially exposure of just leaving the child out somewhere was not the sole cause of death, but it contributed to
But the
it.
answer is no.
Yeah, right, yes. I was just giving some examples of things that I think are somewhat close.
Mr. McGinley, I have a question. Are we misplacing the question of foreseeability for the murder versus any violence to the child?
Well,
And does that change anything?
And that's where I kind of go back with that Wilson case, and I think there is a difference between foreseeability, is if we're seeing the exact method that caused this crime. I don't think that's what foreseeability is. I think it's foreseeability that something, as y'all said in Wilson, something may go wrong. And that's where I see the
Well, but
difference
there's
is.
a big gulf between exact method in which the death was caused and something going wrong. It seems to me there's also a midpoint of foreseeability that the child could die, albeit not necessarily any particular method of the death of the child.
Well, right, but
There's a difference between something could go wrong And something could go wrong that results in the death of the child.
And that's why I go back to the Wilson cases. Y'all said something may go wrong is the exact language from
That's
that
not
case.
actually the holding of Wilson. That's just some language that was used along the way to getting to the result. The holding of Wilson was not, anytime you recognize something may go wrong,
No,
death
just-
is foreseeable.
Right, it was any drug transaction, including marijuana transaction, something may go wrong in that.
Right.
And that's why I go back is the idea that using methamphetamine with a violent individual around your 2-week-old, something may go wrong in that specific situation,
Why
not
do you
just in the
think that
universe.
there is no precedent on this point, directly on point?
I don't know.
Because some options would include that as a matter of law, proximate cause is not sustainable. An option includes that prosecutors aren't bringing cases like this as a matter of discretion. It could be that you're just asking for a new law to be made. I mean, what are your thoughts on that?
I think there may be some,
Or your answer could be that it is not new law and that it's just extending well-settled principles. But those are
right,
the types of arguments been making, and you're getting a little bit of friction here, so I'm trying to expand my view of what could be possible.
I don't think it's new law at all. I think it is just extending it to the facts of this specific case. And
But according to your theory, this thing happens all the time. You're saying this kind of situation happens all the time because people abuse drugs, unfortunately.
Right.
And have children, and that's a difficult combination. But there's no precedent anywhere in the country that you can point to where this situation
Correct.
has arisen. Where there are
And we do
That's
see a
correct.
lot of murder cases like this one where, you know, a spouse or a partner kills, you know, another person's child. But it's always the person who commits the murder that is charged with the crime.
that's correct.
So is it charged this way as a way to actually find a culprit? And-
Well, yes, I mean, I guess obviously I'm going to state charge both individuals because we believe that both individuals have some level of culpability. I mean, clearly, there was never any argument that Mr. McNabb wasn't, I guess you can say, the more culpable individual. Obviously, he was the one that caused the actual injury. And the state was clear with that, I think, from the get-go on that. But that also, Ms. Bell has culpability in this as well for what happened. And I think there's an additional fact that also has to be discussed is because I think someone brought up, one of the justices, I forget who, about as far as domestic violence sort of situation, not being able to get out of that situation. I understand that. That's a concern sometimes, especially a policy concern, and a very big concern even for the state. But this situation where there were other individuals wanting to watch this child. And I think that does make a difference in this case.
But the rule would apply equally to a domestic violence situation, because the rule would be that that felony could be sustained by the evidence presented here.
Right. Yes.
And then that would be
Yes.
the predicate for felony
Yeah.
murder.
As far as the rule overarching, as far as the sufficiency of the evidence, not if a jury would find
Yeah, I
it
mean,
or not.
Help me understand how the availability of other willing caregivers, while clearly a tragic fact, changes the foreseeability of the outcome that was, you know, chosen.
I guess when you word it that way, it's hard for me to say as far as the foreseeability. I think that goes more towards what a jury would find as far as,
Why can the jury look to that for
well,
foreseeability?
yeah, that's a good point. I don't know, off the top of my head. I
As
didn't
to your
give that a whole lot of
point, as
thought.
to your point about it being a jury question, I'm just curious, you would agree that you don't need expert evidence to present to the question of a jury the foreseeability of a wreck and maybe even a pit maneuver, that is, that someone running from the police is likely to result in an attempt by law enforcement to stop them, and that could result in a wreck. You don't need expert testimony.
I agree.
For the average count of the jury to understand that, right? Why wouldn't you need it here, though?
Expert testimony as to the foreseeability?
Right. I mean, for example, is it reasonable to conclude that every jury would believe that using meth singularly, using meth alone is foreseeable to result in the death of the child?
I think it goes back to Justice Gruber's point that is it the foreseeability of what exactly happened, foreseeability that something tragically and terrible could happen to this child?
Even that.
Right.
Is that within the ken of the average juror?
I think it is.
What about alcohol?
I would say alcohol is probably actually more in the kin of the average person than methamphetamine is.
What about abuse? What about taking 10 Xanax a day, which is 4 more than prescribed?
think it would obviously help if there's some evidence, just like there's in this case, of how methamphetamine has affected the relationships of everyone involved. And so it wouldn't be an extra
Thank you,
testimony. But thank you, Justices.
Mr. Crawford, you still have some time remaining.
Well, Chief Justice Boggs, to paraphrase you, brevity may be better. Unless anyone has any questions, I will stand on my arguments.
I certainly have a question.
Yeah.
So,
We do appreciate the effort.
yes, we do. So, as you may have gathered from some of the questions, at least in my mind, the hard question to me is, where do we draw a line? And, you know, is it a line that turns on what drugs were in the home? Is it a line that turns on how many people were in the home? Is it a line that turns on how many of those people were doing illegal things? If there was no meth in this case, if it was just marijuana, notwithstanding what we say about drug transactions, if it was just marijuana, I think that would be much harder to say, you know, it was foreseeable. But meth is different. And your friend across the way has understandably resisted drawing the line based on which drug it was. What can you do to help me with that just concern?
I guess despite because of it being 420 today, I would agree with you on the marijuana that it's a much more difficult line to draw there, certainly given the effects of that on a person.
In your view, does foreseeability turn in part on what drug is at issue?
I think I would agree with Mr. McGinley that it's a totality of the circumstances argument, and plugging and playing the different things that are part of it.
The problem is this is a cert case, and we generally grant cert to try to draw some lines that are useful to the bench and bar, and just saying whether something that can result in a predicate for felony murder is just totality and case-by-case determination does not give a whole lot of guidance.
Yes, and unfortunately, that's why y'all get paid the big bucks to make the decision. So,
It also means most of those cases are going to go to a jury.
yes. I'm sorry, I
Justice LaGrew?
do not have a good answer.
No question?
Just a follow-up, sorry. On your totality, you're sort of indicating, and respectfully to my presiding justice, you're saying marijuana may be different. What if the evidence is that every time they both smoke marijuana, there is horrific violence in the home?
If there was evidence that every single time,
Or
majority of the time.
80% of the time,
most of the time, saying,
would that change your view?
sure, absolutely. Anyone else?
Don't appear to be other questions.
Thank you.
Thank you, counsel. We appreciate the argument from both sides. We'll have you a decision as soon as possible. We will be in recess until the next session of oral arguments.
All rise.